Does the Freedom of Information Law allow police records to be disclosed? To find out, you have to read Matter of NYP Holdings versus New York City Police Department, but it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Matter of NYP Holdings, Inc. versus New York City Police Department. The citation for this case is 2025 New York Slip Opinion 01009, published by the Court of Appeals on February 20th of 2025. The issue in this case is whether the repeal of 50A, which is an exception to the Freedom of Information Law, is retroactive in application, or does it just apply going forward after its enactment? To understand and appreciate the context of this case, the helpful thing to know is, first of all, the Freedom of Information Law is a law that allows members of the public to file requests for government documents. And under Public Officers Law, Article 6, there's a broad duty on the government to make available its records to the public, which furthers government accountability and public accountability of the government. So the public can decide whether they want to reelect people, whether they want to change the law. An exception to all government documents being available for public inspection is found in Public Officers Law 87. Public Officers Law 87 sub 2 says that records or portions of records that are specifically exempted from disclosure by state or federal statute are not presumptively open and available for inspection, which every other document basically is. So all government documents are available for inspection presumptively, unless they're specifically excluded by state or federal statute. And in 1976, the New York State Legislature passed Civil Rights Law 50A, which specifically provided an exemption for all personnel records used to evaluate performance toward continued employment or promotion of certain law enforcement officers. Those are considered confidential and not subject to inspection. That's what Civil Rights Law 50A said. But in the wake of George Floyd's death in June 2020, the legislature repealed 50A, repealed that exception to the public disclosure presumption of Public Officers Law Article 6, which is FOIL. The other thing you have to know is that with respect to retroactivity of laws, there's a couple of sort of axioms that guide courts when they are looking at retroactivity. The first is retroactive application of laws is not favored. Normally, laws are from the moment it's passed going forward. Retroactivity is an exception, which would say it applies going backward in time. That's not the favored interpretation. But remedial legislation should be given retroactive effect. So if there's a problem that's being fixed by the law, that's a remedial legislation, then retroactive effect would be proper because it effectuates the beneficial purpose of the law. Okay. So what are the facts in this case? The facts are that following the repeal of 50A, New York Post, NYP is New York Post, and a reporter from the New York Post filed 144 FOIL requests for specific disciplinary records of police officers. The NYPD denied almost all of these requests, except with respect to one officer. The New York Post then commenced an Article 78 proceeding saying that they're not doing the right thing, and they should be compelled to provide the records. The New York Police Department then moved to dismiss that petition, saying it was so voluminous a request, it would be too burdensome. And ultimately, there was an argument that was made in the course of the Article 78 that 50A was not retroactive. So the documents that are being requested include documents that existed and were created before 50A was repealed. And the question is, did 50A's repeal mean that the documents produced before that were also available for public inspection? And that's the question that ultimately goes to the Supreme Court ultimately grants the New York Post petition, denies the NYPD's argument. The Appellate Division affirmed. They said it is retroactive because it's remedial in nature, and it goes to the Court of Appeals. And here, the Court of Appeals agrees with the Supreme Court and the Appellate Division and says, we conclude the legislature intended for the statutory repeal to have retroactive effect. Why? Because it was a remedial statute intended to fix a problem with the law. And it didn't specifically, the repeal did not change the nature of the normal presumption of the FOIL, which is that all government records are presumptively foilable, or presumptively retrievable and open to the public, except for the exemptions. Basically, the repeal of 50A said this is no longer an exemption. So it would be retroactive because the presumption would apply in general. And that's the holding, essentially, of this case, that the repeal of 50A was retroactive in effect, and prior documents that were created while 50A was around are not protected by 50A. It's as if 50A didn't exist. And that's the case of matter of NYP Holdings versus New York City Police Department. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.